Someone make it make sense.
Probably a couple.
Hello, all of my squirrel friends, old and new. We are covering some more court filings here. This time I'm happy to be with you discussing the brand new court filings out of Idaho, but this time it's for Chad Daybell. So there's a couple interesting things about this document that we're going to go over first. This is the judgment of conviction. So we have here in the District Court of the 7th Judicial District of the State of Idaho, in and for the County of Fremont, judgment of conviction. And this was only just filed on the June 5th, 2024. So the defendant, Chad Daybell, was found guilty by a jury returning a verdict on counts 1 through 6 and counts 7 and 9 of the amended indictment on May 30th, 2024, following the guilt phase of the trial. The court thereafter immediately commenced the special sentencing proceeding under Idaho Code 19-2515 on June 1st, 2024. The jury returned the special verdict. Now, one thing that's interesting to think about too is when it comes to Brian Kohberger, being that that's also in Idaho, if indeed it goes to trial, which seems like it will at some point, right? And he is found guilty, then we can expect similar proceedings in terms of how Idaho handles a death penalty case, because the states that have the death penalty, or those that actually utilize it, of which there are quite few, all have kind of different processes for this. But the way that it was done here with like the special verdict form, we can expect that. Now, I will say briefly, I would imagine there will be quite a lot of differences, because normally there's a lengthy sentencing phase when it comes to a death penalty trial. Ann Taylor, Brian Kohberger's lead attorney, calls it a mitigation phase, but that's exactly what it is. Typically, I've seen it before where it lasts, a week, 2 weeks, or longer, and it's like, they're presenting typically, right, mitigating evidence, mitigating factors. They bring in experts. The defense does. They bring in experts, and it really can make a big difference. There was a trial out of Texas from, a year ago or so maybe, where it was a death penalty case, and it seemed like, considering the nature of that specific crime, it seemed really, really likely that the jury would go for it. And he had public defenders in that case as well, and they brought in a couple different expert witnesses during this sentencing phase / mitigation phase, and went over a number of different things, and the jury returned LWOP, life without parole. So now in Chad Daybell's case, it was unique because he waived rights as it relates to that. Like, he chose not to take those steps. In fact, it was almost evident that perhaps he actually wanted the death penalty, because I've literally never seen that before. It's actually really, in a way, I'm kind of surprised it's even allowed, because, you've got issues, potential appellate issues with like ineffective assistance of counsel. However, I'm sure that they made a very thorough record about this, and I guarantee you his counsel did not advise him to make this decision. We know that they didn't even poll the jury on the verdict or the sentencing special verdict form. And that they didn't take any steps to try to save his life, essentially. But again, that really was his choice. The similarity will be with this special verdict form and the way that the typical proceedings are held, right? The same type of questions will be asked. It's just that the answers will be different, and then therefore there will be steps that were skipped when it came to Chad that will not be skipped when it came to Brian Kohberger. So anyway. Okay, so that's the special verdict. So then the defendant thereafter personally appeared for sentencing on June 1st, 2024, represented by John Pryor. The state of Idaho was represented by Lindsay Blake, Rob Wood, Rocky Wixom, and Ingrid Beatty. District Judge Stephen Boyce presided. On the special verdict, the jury unanimously found that the state had proven aggravating circumstances, and unanimously found that when weighed against the aggravating circumstances, all mitigating circumstances were not sufficiently compelling to make the imposition of the death penalty unjust on counts 1 through 6. Now, another thing, remember how complicated it seemed, right, when they were reading that form, and the whole thing about, the way that the jury has to respond to this form is the questions almost seem kind of like a double negative, right? It's like, I did not find that there was not something that would make the imposition of the death penalty unjust. So I would imagine we're going to see similar languaging when it comes to Brian Koberger if it makes it to that phase, again, because it's the same state. So luckily for anyone who watched the Chad Daybell trial, they will already have some familiarity with that. I understand that some people found that quite confusing. However, I actually thought it made a lot of sense, because I think it's better. I think that the goal is, instead of saying to a jury, you have to give them death, or you have to find that they are deserving of death or whatever. It's a different way to look at it, which is looking for reasons to find the death penalty unjust. In other words, it's like a glass half full, glass half empty thing, right? It's like, let's look for reasons not to do the death penalty, not to give the death penalty. And that's really the way it should be anyway, right? Because if you ask somebody, what are all the reasons they should get the death penalty, they could list off a whole bunch, right? And that could be based on whatever. It's better to say, okay, let's look for reasons not to. Because you're more likely, if you go that approach, and if you put on actual evidence for mitigation, as I referenced in that case in Texas, you will find things. You very likely can find things. And that's the point of it, right? So that all makes sense. I think it's actually a really good approach. And I think it's better for the jury. I think it's better for the defendant, because I think, again, it's whatever you're looking for. If you're looking for reasons not to, I think you can find them if they're presented. I think it's better for the jury because, in other words, for their conscience of feeling like they're telling someone they should have death. I think this is a better way to go about it. We really tried to find reasons not to. So hopefully that makes sense. So the court accepted the jury's verdicts. The defendant thereafter was advised of his right to have a PSI ordered for sentencing on counts 7 and 9, and subsequently waived his right to a PSI. So again, another right that he waived to a PSI. Now, that all would take extra time. We've seen this in other cases, even when it's not LWOP, even when it's sentences of 10, 20, 30 years, we've seen PSIs done, because some states just require it once you pass a certain threshold, and they take quite a bit of time. And again, he waived his right. Lori Daybell did not waive her right to a PSI, by the way. The court thereafter sentenced the defendant to death on counts 1 through 6 of the amended indictment, and sentenced on counts 7 and 9 of the amended indictment. Judgment is entered. Judgment of conviction. Defendant is sentenced pursuant to Idaho Code, blah, 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 to the custody of the State Board of Correction to be confined for a period of time as follows. And there you go. There's all the counts. Okay, so now here's the fines, fees, costs, and restitution. Now there's something interesting here coming up. So when it comes to these fines, fees, costs, and restitution, all of these are the same. As we know, he's indigent. Where it says I.C.R, that's the Idaho criminal rule, 33G. So he's indigent and unable to pay those court fees, court costs. However, it's a different matter when it comes to the restitution. I don't know if anyone's actually covered this, but this is surprising, right? Restitution to the victim. On count 7, the state requested restitution in the amount of $130,000. On count 9, the state requested restitution in the amount of $300,000. The defendant objected to the requested restitution, and the court advised counsel that the defense would be given 30 days to resolve the objection or schedule hearing to determine restitution pursuant to IC 19-5304. That's Idaho Code. The court will therefore issue a supplemental restitution order to set those amounts. So in other words, this is still up in the air. The restitution is different, right? Because that can kind of be done through the prison systems as you're working and you're making money. They can take that, and most people watching this video are probably aware of that. But what's interesting about this is I'm not quite sure. It'll be interesting to see what happens, because whenever the restitution is actually ordered, if that happens, right, and they resolve this, whether it's through an order, like a court document, or there's going to be a hearing to determine it, then we'll find out more information, because what I'm curious about is who will be the recipients of this, right? Because technically, his children can be considered victims, right? They lost their mother. And that's why it's a little bit weird. We'll see what happens. That's one thing I found really interesting, though, about this particular document. So the court will therefore issue a supplemental restitution order to set those amounts once this is resolved. Okay, so now here we get to one of the other interesting things about this document. So we're going to be discussing the appeal now. So right to appeal / leave to appeal in Forma Pauperis. So think about the word pauper, right? So the defendant has the right to appeal this judgment on counts 7 and 9 within 42 days of the date it is filed, stamped by the clerk of court. Idaho Appellate Rule 14A, on counts 1 through 6 pursuant to Idaho Code 19-2719, the time for filing an appeal shall begin to run when the death warrant is filed. The death warrant shall not be filed until 42 days after the judgment imposing the death sentence has been filed, or in the event, which by the way, this is the judgment. This is that judgment. So, or in the event a post-conviction challenge to the conviction or sentence is filed until the order deciding such post-conviction challenge is filed. Within 42 days of the filing of the judgment imposing the punishment of death and before the death warrant is filed, the defendant must file any legal or factual challenge to the sentence or conviction that is known or reasonably should be known. The defendant must file any claims of ineffective assistance of appellate counsel within 42 days of the Idaho Supreme Court issuing the final remitter in the unified appeal, from which no further proceedings except issuance of a death warrant are ordered. So, the death warrant being filed. So let's take a look at that. So here, just so we can see it's clear, we have a reference to Idaho Code 19-2719. So now we're going to take a look in the Idaho criminal procedure, the I.C.R. We're going to take a look at what it says about this whole thing with filing a death warrant. So here we have, this is from the Idaho Criminal Rule 19, so 19-2705, death sentence or death warrant and confinement thereunder. So whenever a person is sentenced to death, the judge passing sentence shall, in accordance with section 19-2719, Idaho Code, sign and file a death warrant fixing a date of execution not more than 30 days thereafter. So now here we are, we're in the Idaho Code, not Idaho Criminal Rule, we're in the Idaho Code, and so this is legislature, right? And so this is from Title 19, Criminal Procedure. So, 19-2719, Special Appellate and Post-Conviction Procedure for Capital Cases, Automatic Stay. The following special procedures shall be interpreted to accomplish the purpose of eliminating unnecessary delay in carrying out a valid death sentence. So, when the punishment of death is imposed, the time for filing an appeal shall begin to run when the death warrant is filed. The death warrant shall not be filed until 42 days after the judgment imposing the death sentence has been filed, or in the event of a post-conviction challenge to the conviction or sentence is filed, until the order deciding such post-conviction challenge is filed. So this was also cited in the judgment that we were just reading. So basically, okay, once the judgment for imposing the death penalty has been filed, the death warrant would be issued 42 days, but not before, right? As it has to be 42 days after that judgment has been filed. But then this is the important part. Or in the event of post-conviction challenge to the conviction or sentence filed, that's your appeal. So, and they're always going to have that, right? So, in other words, it's not like, remember, these things are written and then they're constantly, the legislature, they're constantly updated, right? So I would imagine that probably at some point it used to be, yeah, like the death warrant's filed 42 days after the judgment. So you have a trial, you're found guilty, you have that special verdict with the sentencing. The jury says they couldn't find any reason not to impose the death penalty, and then you have the judgment coming out imposing the death sentence, and then 42 days after that, death warrant would be filed, and then that's that. But as we know, these are automatic appeals, so that's why that languaging is first, and then it has this or, right, in the event of a post-conviction challenge, that's appeal. So that pauses the death warrant being filed. Whenever a judgment is ordered, that has to be carried out. And in this case, it's a death warrant. But then now there's going to be things that stop that from happening, like the appellate process. So in other words, that's why we hear the terminology of like they've exhausted all of their appeals, right? So once all those appellate processes are exhausted, then it goes back to that original judgment, and there's a 42-day period where it can't be filed, but then after 42 days, the death warrant would be filed. So hopefully that makes sense. So now that we have a better idea of what is happening here, again, Idaho Code 19-2719, we just read that. The time for filing an appeal shall begin to run when the death warrant is filed. The death warrant shall not be filed. This is what we were just going over, until 42 days after the judgment imposing the death sentence has been filed, or in the event of a post-conviction challenge. This is literally exactly what we just read. Challenge to the conviction or sentence is filed until the order deciding such post-conviction challenge is filed. So hopefully this all makes sense now, right? Within 42 days of the filing of the judgment imposing the punishment of death and before the death warrant is filed, the defendant must file any legal or factual challenge to the sentence or conviction that is known or reasonably should be known. The defendant must file any claims of ineffective assistance of appellate counsel within 42 days. So again, this is going through all, this is just outlining all of those steps that after this would be on down the line, right? This is after the appeals, then they can file ineffective assistance of appellate counsel, right? And again, once they've exhausted all of those steps, like we were just saying, from which no further proceedings except issuance of a death warrant are ordered. So it's like once they've exhausted all of that, like I was saying, no further proceedings, right? The last thing goes all the way back to this document right here, this judgment of conviction, and then the last thing is the issuance of the death warrant. So hopefully that makes sense. In Forma Pauperis, the court further advised the defendant of the right of a person who is unable to pay the costs of an appeal to apply for leave to appeal in Forma Pauperis, meaning the right as an indigent to proceed without liability. So this is just saying that because he's indigent for the appeal, he's going to be provided with counsel. And then this is the important part here. This appointment must be made in compliance with the standards in Rule 44.3, and the attorneys appointed must be someone other than counsel who represented the defendant prior to the imposition of the death penalty. This new counsel will not be considered to be co-counsel with any attorney who represented the defendant prior to the imposition of the death penalty, and may also be appointed to pursue the direct appeal for the defendant. So John Pryor's involvement in this is done. Order of commitment. Defendant is hereby committed to the custody of the Idaho Department of Correction for delivery forthwith to the Board of Correction at the Idaho State Penitentiary or other facility designated by the Board of Correction, Idaho Code 20-237. It is so ordered. June 5th, 2024, signed by Judge Boyce. All right, so now we have one other document. This is the order appointing appellate public defender. Okay. So, in the District Court of the 7th Judicial District of the State of Idaho, in and for the County of Fremont. Order appointing appellate public defender. The above-named defendant, Chad Daybell, having been convicted of all charges against him in the amended indictment and pursuant to Idaho Criminal Rule 44.2 and Idaho Code 19-5905 A and G, shall have appointment of qualified counsel for post-conviction review and special appellate proceedings. The court has previously determined that Daybell is an indigent person entitled to the services of the state public defender for all forthcoming proceedings. Accordingly, it is hereby ordered 2 qualified attorneys with the state appellate public defender shall be appointed to represent Daybell on appeal in the pursuit of any post-conviction relief. The state appellate public defender's office is provided the following information concerning this case. The defendant's trial counsel is John Pryor. Whoa, that's crazy. And 2, so that's number 1. The defendant's trial counsel is John Pryor. Number 2, defendant's counsel has advised the court that the defendant's current address is Boise Correctional Facility, P.O. Box 51, Boise, Idaho 83707. It is so ordered. June 6th, 2024, signed again by Judge Boyce. And then here's the certificate of service. So, okay, so there you have it. So that is the 2 new documents out of Idaho for Chad Daybell, the judgment of conviction. And as we've learned, in a death sentencing case, like, this is a big deal. Because this is the thing, this document right here is what gives the state the right to issue a death warrant for a person. That's what we've learned. It all comes back to this. As cited in all of the criminal rules, in the code, all of that, the legislature, all of it, all the languaging, it comes back to this right here. And again, what we've learned too is it's the 42 days. Is like, that's the standard. It's like 42 days. So with the judgment of conviction, it's 42 days before death warrant, with the exceptions of all of the appellate things that happen in between, right? And then once those are exhausted, again, comes right back, judgment of conviction, 42 days. Now, we've heard of, there are special cases, right, where there's other things that can go on. I believe those are done more like from petitions to the governor and things like that, and not through this traditional avenue of the appellate process. But we will continue following everything with this case. Of course, that will be years and years and years and years and years down the road. But, this is that we will learn. You'll continue to learn together. And, yeah, so that's that for Chad Daybell. But As always, keep your eyes peeled. I will always be following for any new documents as well for BK in Idaho, Brian Kober. And of course, for anyone who's not, who wasn't aware of this, I'm also covering Karen Reed right now. I am doing recaps for that, but also whenever I'm available, I am covering the trial live as well. So I do also have playlists for all of these different trials. I've got a really great deep dive that we did on the Murdoch trial. So there's a playlist for that. And then, of course, there's playlists for Karen Reed and for Brian Koberger. And now there's going to be a playlist as well for Chad. And then, of course, there's various playlists as well for Depp v. Heard. That was actually how I kind of got started covering legal proceedings, court documents, trials, and the like, was through Depp v. Heard. And so there's various playlists for those as well. All right. Thank you for watching. Thanks for being a squirrel. See you guys next time.